Everybody hear me okay?
Yes, sir. How are you?
So far, so grand.
Hey Andy, can you cross Smith?
What's that?
I was wanting to know if Eddie would cross Smith.
No, I'm the prosecutor for the first hour. When everybody gets in class, I'm going to explain how this is going to work tonight.
I don't know where they are.
Huh?
I don't know where they all are. I guess they're used to everybody being late.
They better show up. My eyes are bleeding. So,
Mine too. I've been up since about 4:30.
Well, odds are if they don't show up, it's because they didn't do the homework. Kids always play hooky when they didn't do their homework.
So that the communication I got from the court wasn't what I thought it was. It was I guess they were looking at that piece of paper and saying that I can't change the date for the, I don't know what they're doing. But that wasn't our motion to quash that we denied.
It was or it wasn't.
Was not. It was a motion to deny a change of date, which I'm not really sure where he got that request. Oh, actually, the court did ask me in an email last week if I could come in. I guess it was like sometime this week, and I told him no. That I said the clerk told me that there was no other dates even through October except for the one date that she scheduled for. And she goes, "Well, I thought you might want to come in and do the motion." And I gave her some more dates that I'm available to do it, but she replied and said, "No, we'll just do everything on the 16th." Well, then the communication today was like just the pretrial motion is going to be on the 16th, which that's the way it should be, and not have the actual trial on the 16th.
Well, the motion in limine you sent me, you're correct. It's not quite where it needs to be, so you still got some work to do on that. And I need you to get to work on that as soon as you can because you need to get that file before you're within 10 days of being in court. You can't file it if you're any closer than 10 days. I mean, you can always make the motion while you're in court, but the likelihood of them granting it, that's a different story.
What about the likelihood of them granting this one in writing?
Well, again, we don't care if they grant it in writing or not. The judge has to issue an order either way. So the order is the writing that you're wanting. We don't care if the prosecutor responds to it or not. I'm surprised they have this many times.
But I was reading today that a motion in limine does not cannot preserve an error on appeal.
Right. You still have to object to errors whenever they occur, Jane. Those are two different things.
Okay. Well,
Okay?
I mean,
A motion in limine is you asking the court to prevent the other side from presenting or talking about something. Period.
exactly.
Okay? If you let them get it in without objecting to it, then the motion in limine didn't help you.
You have to object every time.
Every time they pull something they're not supposed to, yes, you have to object. That's how you preserve error.
if
If you
so
fail to object, then it is no longer an error.
okay, so then as far as questioning Smith, I'm not going to ask that her statements, even though they don't allege an offense, that she not be able to speak about those, correct?
Again, we're making the motion in limine to limit the testimony of witness to only those things of which they have personal knowledge that pertain to this case.
Okay, right.
Nothing in her statement alleges an offense.
Okay,
The animal control supervisor should have known that.
right.
However, the animal control supervisor ordered a citation be issued based upon the fact that there was a sworn statement that didn't accuse anybody of anything.
Exactly.
So that puts the supervisor on the hook. Then they put their officer on the hook by telling them to go write a citation for something that was not an offense to begin with and for which they had no personal knowledge and did not occur in their presence or view.
Right. But
Not a single witness they're going to call to the stand has personal knowledge of anything that resulted in a violation of any part of that ordinance.
even Smith, I realize that. But since Smith wrote the statements, is she not allowed to say what's in there?
If we challenge the statement as being irrelevant and inadmissible, Jane, no, she can't testify to what's in there if the court sustains our motion.
Okay.
Or grants our motion, I should say.
Even though she has personal knowledge of nothing really, but I mean,
She has personal knowledge of her bitch and gripe session that she put in writing, Jane. That's all that fucking statement is.
I know.
A bitch and moan session. That's it. It's got nothing to do with a crime.
I know.
Well, then why are we discussing it? I've already told you that's why. Why do we still have to go over it and debate it?
We're not. I'm just saying that I know that I can prevent the officers from not saying anything about the statements, but since she wrote the statements, that's what I was asking. That's the only thing.
Again, if the statement is irrelevant to an offense for which you're being prosecuted, because it does not allege any such offense, it shouldn't be admitted at all. If it's not admitted, she can't talk about it. And there's nothing left for her to get on the stand and talk about, period. Because the video has the exact same problem. It isn't evidence of any crime. There's nothing in it that shows any element of that charge at all.
I agree.
Therefore, the video's irrelevant. So what is Smith going to testify to?
So I'm asking you again. The
I
motion.
wrote a statement in a video that you won't admit. That's all she can say.
Okay, in the motion in limine, instead of the motion to suppress, is going to address that, what you're talking about right now.
Yes. I told you that's what the motion in limine does. It's more broad. The difference between the two is the motion in limine can be used to prevent them from talking about pretty much anything or presenting any kind of evidence for anything, whereas a motion to suppress is going after evidence or testimony that was gotten illegally. A bad search, coaching of the witness, intimidating a witness, etc., etc., etc. All the things that would make that testimony or evidence illegal to admit in court, or fruit of the poison tree. That's what a motion to suppress is versus a motion of limine. What we're going to do with the motion in limine is ask the judge to rule on the admissibility of the statement and the admissibility of the video based upon the fact that they do not present evidence of any crime.
Okay.
They are not a sworn statement alleging any crime.
I don't even know how we get to that, but there's no probable cause in this case.
Well, they think they don't have to do probable cause in these types of cases, but they do. If they're prosecuting them as crimes, they damn well have to have probable cause to do it.
Well, now that has me thinking and scratching my head about my case. Because
Why? They do the same thing in every misdemeanor case.
Well, exactly. In my case of the defective equipment headlamp, it's kind of the same thing because he says, I have probable cause to pull you over. What probable cause? There is no offense codified.
Well, as far as the officer side of it, he'll be covered by mistake of law, which is a judicially created doctrine on the officer's entitled to not completely know the law and make honest mistakes.
But then I have to object to that and say if he's going to enforce such law,
You
then
can object, but it's not going to change anything. That's not the point of your defense, okay? The point of your defense is there was no, the probable cause was based upon a bad assumption of law. That's your
Okay.
defense to the charge, but it's not a defense to the stop.
Mm-hmm.
Now, the officer should have done a proper investigation and read the fucking statute, but he didn't.
No, of course he didn't.
And they never do.
No.
And that's where the judge should catch it in his probable cause hearing, correct?
If the judge does one like he's supposed to, yes. The problem is, in misdemeanor cases in Texas, they don't do them.
And they tell you they're not required.
Right, which is a violation of due process.
So I was looking on the Texas next book. I know it's about a TMC, and I know that stuff's, you know, and they don't say who actually authored it. It's a whole bunch of people, like the staff or whatever. But anyway, they mention in there about the motion to suppress, but they don't even bring it name. But that's not my point. My point is on the 39.14 of the Texas Code of Criminal Procedure on that discovery violation.
Jane, you're talking from the bottom of a well.
I'm sitting right in front of my computer.
Well, I can't help that. You're still talking from the bottom of a well.
I don't know what's going on with that. Is that any better or not?
Yes, that's better. Not a lot, but more so.
Okay. I know where that prosecutor got the information that how she had the discovery violation, because the Texas bench book says that there's a distinction between the pro se and an attorney for a defense. Well,
And that is their misinterpretation of the law. That's not what it says.
exactly, but they go a lot further into it, and you know how, you know, the pro se is not allowed to get this or that or whatever. And so I was trying to figure out who is the one that updates the bench book, and it's a whole bunch of people that do it. But,
It is. It's a committee that does it.
Yeah, and there's no names on it, though. It's just all, you know, the staff or whatever of the PNC.
Well, you complain about the committee to the Attorney General's office, that they are intentionally misinterpreting the statute and mistraining the lower courts and city attorneys and other prosecutors in pro se cases to deny them their right to discovery in a criminal case.
Right, and that's not, I mean, they do misinterpret pretty much everything, you know. It's
Yes, they do.
not,
All right,
so,
we're not going to get bogged down in all this superfluous shit. This is how this is going to work tonight. Jane, you will play your part tonight. You will have 1 hour to get your case won, okay? I'm going to play the prosecutor. Somebody else needs to play the judge, and somebody else needs to play the individual witnesses. Now, Jane, it will be up to you to make your own objections. I'm not going to coach you. I'm not going to do anything but play the part of the prosecutor.
so then afterwards, we're going to have a,
After that hour is over, we're swapping places.
oh, wow,
Somebody else can do the prosecutor, and I'm going to be you.
good. And somebody needs to play Smith at that point. I can, you know. I wanna see-
Now, when we swap, I need everybody writing down what I ask as a prosecutor, because you're going to have to ask the same thing when someone else takes over the part of the prosecutor.
Well, it's going to be hard to do as fast as you talk and everything. Yeah. Oh, well, okay.
Well, can't help that, so figure something out. Now, does everybody understand the rules of the game?
Now, where's Julie?
I don't know. I haven't gotten any email from Julie, other than saying that she still is getting email and an email address that my thing won't delete for some damn reason.
Eddie, is the judge in this supposed to be an idiot judge or a fair judge? In which case this ends 10 seconds in.
I only know the former, never the latter.
Probably just.
It's a municipal judge, therefore it will uphold damn near anything the prosecutor does while overriding almost everything the pro se does. That much you can bank on.
So do we expect to lose at this point?
We always expect to lose at this point. If you go in expecting anything different, then you're an optimist, but you're also an idiot.
Okay.
So am I not to present my open statements and the motion to limine because we're short on time or what?
You got an hour, Jane. Can you do all that in an hour?
I don't know.
Plus the case itself?
It's going to depend on the prosecutor and how, everything getting through all that. So,
Okay, has everybody got their sound and audio issues and everything worked out? I need a volunteer to play the judge. All you have to do as a judge is overrule or sustain the objections
I'll
and
do
answer
it.
questions if they get asked.
I'll do it.
Who's I?
Heidi.
Heidi will do it. Okay. All right, let me get the ordinance pulled up here, and then we will get started.
Well, there's really no point in me doing opening statements because it's just us, right? And even probably there's not any point in doing it with the judge, but I will anyway.
You can do it if you want to, but like I say, it's your hour.
No, I'm not going to do that because I'm just going to, because I already got that. I can use that for court. And the motion in limine, that's not going to get granted anyway, so I don't know if we should even pay that.
Where in the hell? Oh, that's why I can't find it. Sorted on the wrong thing. There we go. Now, I'm going to put the ordinance up on the screen so everybody can see it as we do this.
So let's leave out Hollinger and just do Delgado, huh? Or not?
I'm going to present my case.
Why
You object when you need to object. You do your part.
Okay.
Whatever you think that actually is.
Well, I got objections.
Alright, y'all tell me whether or not you can actually see this when I get it up here. Can y'all see that well enough to read it? Or do I need to make it bigger?
That's fine.
Yeah. Pinch it out and move it.
Okay, Judge, at this time the prosecution would like to call Jody Smith to the stand.
You're not
Who
going to
is-
call her first.
How do you know who they're going
They're
to
going to
call
call her
first?
last, like they've done before, because the reason why they do that is because they want me to have already crossed the other two before I crossed her, and when she doesn't have any evidence.
Jane,
Okay.
the first thing you should be doing before I even open my mouth is asking the judge to exclude the other witnesses from the courtroom during testimony. So
Okay.
they can't listen to each other's testimony. And to also instruct the judge to not allow them to talk to each other when they are not in the courtroom.
Okay, Judge. I move to exclude the witnesses who are not testifying at the moment to be excluded from the courtroom while the other ones testify, and also have them separated when they're out of the room.
Denied.
Not just separated, they are, and I ask that they are not to communicate while they are outside of the courtroom either.
And I ask that they are not able to communicate when they're outside of this courtroom. And the judge said denied. Is that something that the judge would do?
Not normally. Exclusion of witnesses in a criminal case is very normal when you're worried that they will repeat their testimony based upon what somebody else testified to.
Right.
Okay. I'll allow it.
Okay. All right. And also, Your Honor, I'd like to ask that the attorney not make, city attorney not make any or elicit in any manner respondent's prior court cases, convictions, investigative report, or allegations made against the respondent on any other interactions with any person or agency of the city, animal control officer, and that's not directly related to this case only.
Judge, I object. That's an improperly formed request, and I ask that the court deny it.
Well, it's a motion in limine.
Not the way you said it, it's not.
And I didn't say motion in limine. I was trying to get to meat. But,
Yeah, you kind of have to do that if you want to make a motion in limine. The first thing you should have to say is, Judge, I would like to make a motion in limine for the following things.
okay, act like I said that. And also, Judge, I'd like to motion in limine that statements made or video evidence provided by Jody Smith not be discussed or questioned in this matter because it doesn't allege an offense.
Okay. Let me back us up here for 1 second. Let me explain something about the procedure, Jane, that you're not getting.
Okay, well, just now I got this on my
In
lap.
order for the judge to grant your motion in limine, the judge has to have ruled on whether or not the evidence you're asking her to suppress is even admissible. You have not requested a hearing on whether or not the statement is admissible, the video is admissible, or testimony without personal knowledge is admissible. You haven't asked the judge to inquire into any of that and rule on it.
Is that something they would do before the trial on the merits?
Yeah. Judge, I would like an evidentiary hearing, please.
Okay. Is that before the motion to quash?
No, it's before the motion in limine, because if the judge grants the evidentiary, any part of the evidentiary hearing in your favor, then that's what you can ask for a motion in limine on.
Okay, so evidentiary hearing needs to be done before the motion in limine.
Yeah.
Okay, well, that's something we still got to do.
Unless you're going to do them simultaneously. Judge, I make the motion in limine and I request that you conduct a evidentiary hearing based upon what I'm about to ask for in the motion in limine.
They probably don't even know how to do that, but I can try. I'd rather do the evidentiary hearing beforehand. But anyway, okay. So that was denied.
We don't know. The judge hadn't ruled and you hadn't tried to make one.
Judge,
Yes, ma'am.
I would like to file this motion. I don't know how to say this. Present this motion in limine to disallow the city attorney from mentioning or attempting to elicit in any manner any of the respondent's prior court cases, convictions,
Get
investigations,
away from the goddamn gate and shut up!
or any allegations. Damn, Eddie.
No!
Or any allegations made against the respondent or any other interactions with any city agency. You can't talk to animals like that. Oh, sorry.
Are you asking for an evidentiary here?
Oh yeah, I would like to ask for evidentiary hearing on the actual evidence that's being used to make the allegations against me. So,
Judge, I object. There's no irrelevant evidence in this case.
can I rebut that? Or may I reply?
You can reply.
There is absolutely zero evidence in this case at all because there's no offense alleged in the complaint or any of the video evidence or the statements made by the complainant witness.
Judge, you've already ruled on this. When you denied the motion to dismiss, you ruled that there was enough information in the complaint to move forward.
Motion denied.
Okay, well, he hadn't ruled on that yet, but still, he will deny it. But anyway, okay, go ahead. Oh, wait a minute, Judge. So you're denying my motion to limine when there's no evidence in this case? And I raise an exception to that. And,
Objection, Judge. The whole purpose of having a trial is to present the evidence in the case so that the prosecution can be carried out.
but the judge needs to view or study what the evidence is to see if it actually alleged an offense, because it does not.
Prosecution's objection is sustained.
Jane, the proper way to ask for it is the defense requests an evidentiary hearing to determine what will and will not be admitted as evidence in this trial.
Okay, well, I haven't had anything on this until this morning. Let me put this on my lap.
You're supposed to be doing reading and knowing how this works.
I was trying to figure out how to just even write the motion. But anyway, okay. At least we got it on video. So it's denied, and I guess go ahead. But still, I'm gonna raise an exception to the judge.
There's no need to raise exceptions. Exceptions are duly noted as already pre-existing. Anytime you get an adverse ruling, it's automatically assumed you take exception to it.
You don't have to do anything to preserve the error?
Nope.
You raise the objection, Jane. The exception doesn't do anything extra except add words to the transcript, thus increasing your page count, thus increasing your overall cost.
Okay. So I object to judicial error then.
Noted.
What judicial error, Judge? What is the defense talking about?
Well, it really should be excluded, shouldn't it?
I'm sorry, Judge. What should be excluded?
All right, we're still in character.
You're breaking up really bad, Judge.
I'm sorry. Is that better?
Yes, sort of.
Okay.
Guys, real quick, if y'all want to participate in class, try not to use microphones built into laptops and shit. Get a decent headset with a good mic.
Give me a second. I may have one.
Okay.
That way everybody can stop sounding like they're coming out of the bottom of a well or half their words disappearing into digital death and not coming across at all.
Man, I ain't ready at all for this.
I guess we're going to find out. Judge, are you back yet?
I am. I'm back.
All right. The prosecution calls Jody Smith to the stand.
All right, Jody Smith.
Who wishes to play the part of Jody Smith? Somebody jump in.
Helen ought to play her. Helen. Helen, all you got to do is lie like Smith does. Where'd she go? Maybe Rebecca wants to play it. Randall?
Which role are you looking for?
The complaining party, the neighbor.
Yeah, I'll do it.
Okay.
All right, now we're going to talk about dates and times, but they don't have to be the ones that are actually accurate. We're just going to make them up as we go. Jane, you just need to realize that if they're inaccurate at trial, you need to object to that.
Okay.
But so I don't have to have 500 different pieces of paper open on my computer screens, I'm going to wing the dates and times. You got it?
Okay.
Okay. Now, Ms. Smith, you signed a statement on October 27th of 2024 alleging that the defendant in this case was feeding animals outside of her home, correct?
Yes, that's correct.
And in this statement, you allege that the defendant was feeding animals at all times of the day and night.
Yes.
Okay. And how long have you been observing the defendant do this?
Several years now. I see her doing it daily.
Okay. And have you complained on the witness before?
Yes, I have.
And do you know what the results of any of those complaints are?
I don't. They must not do anything 'cause she keeps continuing to do it.
Okay. And you also recorded a video of the defendant on the day in question placing something, food outside for animals, correct?
Objection, Your Honor. There's no evidence. There's no video and evidence.
Overruled.
I am Judge. I'd like to respond, please.
Go ahead.
Miss Smith is the person who created the video, and I would like to ask her if she made such a video before I ask the court to allow us to introduce it so that we know where it came from and what it depicts.
Okay.
I'll allow it.
Yes, I did make a video.
Okay. And you gave a copy of that video to the animal control officer, correct?
Correct.
Okay. And you made this video yourself on your own,
Yes.
on your own home system?
Yeah, it was on my home system, my camera.
Okay. And you just made a copy of that unedited directly from your recording device and gave it to the officer?
Yes, that's correct.
And can you describe what is shown in the video?
It shows animals eating the food that she had put out.
Okay. Judge, at this time, I would like to play the video in question and see if the testimony of the witness...
I object, Your Honor. There is this, the video does not even allege, it doesn't show an offense against the state law, the laws of Texas, and also no offense against the ordinance either.
Overruled.
Judge, we haven't shown the video yet, so we don't know exactly what it shows. But we have an allegation from the witness that what it does show is the defendant feeding animals outside.
May I reply?
You made
Yes,
the
ma'am.
objection. I'm replying to your objection.
Okay, so objection. Okay, objection, Your Honor. The video does not show an offense, and
Well, we
so
haven't seen the video yet, Your
I'm
Honor, so
trying
we
to-
don't know what it shows.
I'm trying to prevent the video to be entered into the record because the video does not show an offense, and neither do the statements.
Judge, if the defense did not want to have the video shown, the defense had time prior to trial to make an objection and either a motion to suppress or a motion in limine to get it withheld, in which case they would have had to been an evidentiary hearing, which the defense also did not request. Therefore, the video is fair game to be entered.
I'm going to deny the objection, and we're going to go ahead and watch the video.
Okay. Then I'm gonna raise judicial error. Not judicial. I object. I'm raising an objection.
You already objected, Jane.
Okay.
Objecting after the objection and after the ruling, objecting again doesn't do you any
I
good.
object to the ruling too.
Denied.
Okay. Duly noted.
See, Jane, this is where you get off on the wrong foot.
I know.
You made the objection. The objection was overruled. The error is preserved. Shut the fuck up!
Okay.
The more you argue, the more you cloud the issue. Stop doing that. You're killing yourself.
Let me hang myself, Jane. Let everybody else hang themselves. Just do what you're supposed to do. Say what you gotta say once. Let us hang ourselves.
Mm-hmm. Okay.
And if the evidence doesn't show the offense, let the court see it, because it'll prove your innocence.
Exactly. Preserved. It's all on the record, Jane. Let it be. It's all going for you upstairs.
But you
Just let it be.
have to preserve error. This is my point. So.
It is preserving the error.
When you said
You're killing
objection,
yourself
Jane,
over the
you
smalls.
preserved it. Which part of that is not clear to you?
Okay.
Once the judge grants or denies the objection, sustains or overrules it, okay? That's all there is. You preserved the error, the judge made the ruling, move the fuck on. Arguing over and over the same shit's how you wound up in jail last time. There's not a need for it.
That's not what happened. Yeah.
Just ignore it, Jane. Move on. Let it go. Let the judge make the error. Let the prosecutor get his ass into hot water. Just let it go, because upstairs it's going to work out for you. You got to have that faith. Let them make a fucking circus of it at this end of it. That's fine. That's what you expect to happen.
Okay.
Let them make the case for you upstairs.
All right, moving on. All right. Now, we all know the video shows 3 cats, 2 over at Jane's house, 1 sitting on the hood of something, a car or whatever out there. Isn't that accurate, Jane?
No, sitting in the flower bed, my flower
Well,
bed.
whatever. In any case, it shows only 3 cats, right?
Yes,
Okay. And Jane, right?
just briefly.
Okay. But does it show the actual bowls once they're on the ground?
Huh. Yeah, it shows cat. They're clear plates. You can't really see them. So
Again, do you place them down in view of the camera, and the cats
Yes.
gather around them?
it shows from my behind. It shows me from the back of my head sitting something down on the ground. You can't really tell what I'm putting on the ground, but I do see one cat come to one plate and another cat going to another plate, and they're eating from there. Yes.
Okay. And that's the only 2 cats that come, correct?
The other one's sitting in the flower bed.
And no other cats come to the plates, correct?
Nothing at all. There's no other evidence of any kind of species,
I
animal.
swear, Jane,
Nothing.
you are the most blind person I know. You cannot take a fucking hint to save your life.
There's nothing else in there.
Okay, never mind. I'm through throwing you life preservers. Let's get this done. Okay. Now, Miss Smith, the video clearly shows that the defendant is sitting something on the ground that appears to be food, and we believe it to be food because the 2 of the cats run over to what she sat on the ground. Correct?
Yes, that's correct.
And again, just for the record, this is the video that you made a copy of and gave to the animal control officer.
Yes.
Okay. Judge, that's all for this witness.
Thank you. Defense?
Oh, so I was okay. This is for Smith. Miss Smith, did you? I don't even. I told you I wasn't ready for Smith. I'm not ready for anything now. I'll tell you the truth. You threw me off. That's not your fault.
I know that.
I know it's not your fault, but you shouldn't have me write these 2 damn motions today, and I could have been getting my stuff ready for Smith. Told you I wasn't ready.
Well, Jane, you have to learn to think and act under fucking pressure. Not everything's going to fall in place, and you're not going to be 100% prepared for everything that comes down the fucking pike. That's why you have to learn to think on your feet and on the fly. If you can't do that, you've already lost the case. Because you cannot know with absolute certainty what's going to happen in that courtroom. If you cannot determine what your course of action will be based upon what happens in real time, you are fucked.
Okay, Smith, you provided a video to animal control, correct?
Yes, I did.
Objection asked and answered.
Sustained.
Other than the brief sighting of the back of the respondent's head, how many cats are in the video in total?
There's 3 cats in the video I have.
And there is no other animals, no other species, human or animal, that's in the video, correct?
It shows you in the video.
Okay, and you went to the animal control campus and
Can't hear you, Jane. Talking to your microphone.
you had some statements notarized by the, I don't think I should ask about that, never mind. You alleged in your, no, we're not going to bring up the statements, right? Let's see. Did you get any kind of coaching from the animal control people of what to write in your affidavit, your sworn statements?
No.
So where did you get the idea that what you wrote was an actual offense?
Because I saw you intentionally feeding the animals.
But where do you derive the fact of me feeding animals has anything to do with an offense of the city?
Because
Yeah.
it's creating
Objection, Judge. The witness isn't required to know what is or isn't an offense. The witness is only required to write down and swear to the facts as she understood them about what was happening.
Sustained.
Well, you allege that that the respondent has continues to feed at all hours of the day and night, and mostly at night. But your video evidence doesn't show that.
Stop.
What?
Where was any testimony elicited mostly at night?
That's what she wrote in her.
But there's been no testimony to that point, Jane.
Okay,
And no
so-
one introduced a statement as evidence.
Okay.
Therefore, why would you keep digging into the fucking statement? That's the part I'm trying to figure out.
Okay,
But this is your defense, so you go right ahead.
No, I'm appreciate
Okay.
the.
You can keep shooting holes in the bottom of your boat. I'll sit here and wait.
Okay, so we've already agreed that there was no other animals or anything in the video. So, and the cats in this video they're not aggressive to one another, are they?
In this video, no.
And are they aggressive towards the respondent?
Objection, relevance.
Sustained.
Jane, you do have a chance to respond to my objection. If you want it, you better say it.
It's relevant, Your Honor, because that's one of the allegations. That's what I'm being charged with in the complaint. And one of the
Objection, Judge. Nothing in the complaint alleges that she had animals that were aggressive.
No, but what is in the complaint is that I created a danger, and that's why by the manner of feeding, and that is why I want to establish if there was any dangerous animals in the video or in the evidence. Or
State's objection. State's objection is sustained.
Okay. So, so there was no animals acting aggressively towards the respondent or each other. So what is your evidence that proves that there is a danger to the public health and safety?
Objection, Judge. The witness is not the one that produces evidence here. The prosecution is. And the evidence that we have thus far is this witness's testimony.
But she provided the video evidence as it alleged.
And we have the witness's testimony in support of that video evidence.
But the video evidence doesn't allege an offense, but neither do the statements made by the witness.
According to what's in the complaint, it alleges an element of the offense that we need to prove, that you were feeding animals outdoors.
There's nothing in her evidence that even alleges, that even matches up to what it says in the complaint.
That you fed an animal outdoors?
There's nothing in the ordinance that I'm being charged under that says anything about feeding animals outdoors. Where they can be fed, the location. I could be feeding them in my house, in my kitchen.
Judge, the ordinance doesn't say whether or not the feeding has to occur indoors or out. It simply says that the feeding has to be done in a manner that creates one of the public nuisances listed in the ordinance.
Objection sustained.
Objection, Your Honor. There has not been any testimony providing that the respondent is the owner of any animals in the video or in the witness's statements.
Judge, no one's mentioned anything about the owner.
Well, the owner, the respondent has to be the owner in order to create it, in order to have intended.
The prosecution has not presented all their evidence yet, Judge. The fact that this witness may or may not know whether or not the defendant is the owner is irrelevant.
Okay, so
Overruled.
All right.
Overruled at this time. The defense can bring that up again later.
Okay, so Smith, there's only you testify there's only 3 animals in the video evidence, but where's your evidence that there are more than 10 animals ever congregating around the food source.
I see them when I come home. There's always animals day and night.
But have you counted how many animals there are? Do you have evidence? It doesn't matter what you see. Do you have evidence to show that there's been more than 10 animals gathering around the food source?
Objection, Judge. The witness can testify as to what they saw. If the defense doesn't like what they saw, the defense can offer evidence to disprove what the testimony of the witness is. They don't get to just say that they can't testify to what they saw.
Objection, Your Honor. The defense is not required to produce evidence to defend themselves, you know.
So Jane, you're rebutting
the defense is required
objection.
to provide whatever they need to rebut the evidence presented against them. But I have every right to present the testimony of this witness, including what they saw, whether they recorded it or not.
Well, I have a right to object to that because there's no evidence there ever was more than 10 animals, which is what the ordinance requires.
Well, that's a separate argument, isn't it, Judge?
Objection sustained. It is a separate argument.
Well, that's what I'm being charged with, though. One of the three things have to be met, and none of those have been met.
But you got to stay on course, Jane. Stay with where you are right now. Don't be jumping all over the board.
There's three things that this witness I have to disprove in this witness only. Those three things. One, two,
Are you telling the judge exactly what it is you have to prove or disprove?
Yeah, I guess I am. So.
Objection, Judge. This is not a debate or a discussion. If they wish to put on a defense, let them do it. Otherwise, ask questions.
Sustained.
All right. So, Smith, do you believe that the property you live on, 810 Ventura Park, is public property?
No, private property.
Okay. Do you believe?
Objection. The witness doesn't have any personal knowledge as to what type of property this address is or isn't.
Objection, Your Honor. She bought the place. She knows whether or not she owns the property or not.
Did you give her address or yours?
I get her address.
Okay. Then I object to relevance.
Relevance.
There's no foundation laid for asking any questions about a particular address.
I am being charged with an offense that alleges that one of the three elements or the facts is that I would have had to create a danger to public health and safety. So
irrelevant, Judge. There's still been no proper foundation laid to ask the witness a question about some address that no one's testified to.
Sustained. Move on.
Well, that prosecutor didn't present his case then, did they?
Why does the prosecutor where is the need for the prosecutor to present the address of a witness as part of the evidence in the case? Unless the crime occurred at that address.
Well, where's the but they didn't even ask about where the offense even occurred.
We haven't called all of our witnesses yet, Judge.
Sustained.
You think that how's an animal control officer going to know where she lives and what she owns? You know. Anyway. Okay. So the only thing about public, I think. Okay. Do you have any evidence showing that the actions of the manner of feeding by the respondent has created any damage?
Objection, Judge. The witness is testifying to what they saw and what their camera recorded. That's the evidence.
Okay, I'm trying to figure. Okay.
Hmm? Yeah, sustained on that.
This is not going anything like it's going to go in court. So, but anyway, it's not. There's going to be more foundation laid before.
By who?
By the prosecutor.
That depends on what the prosecution thinks they need out of a particular witness, Jane.
I mean, they ask all those questions like, to establish the foundation, the minimal stuff.
And you're not giving me anywhere else to go with the objections.
What do you mean I'm not giving anywhere else to go? I'm trying to.
I know you are, honey. I know you are.
All right, so pass this.
All right, Jane, if it'll make you happy. Miss Smith, can you please tell us what your street address is?
No, I'm not going to do that. I'll just come back to this
No,
witness.
not you, Jane. Suspend for a second and let me lay the foundation you want. Miss Smith, can you please tell us what your address is?
Yes. I live in the city of Irving, Texas. It's on 802.
808.
Okay. And is your address directly next to or across the street from the defendant's address?
Next.
Yes.
Okay. And that address would be what?
808.
808, the address I just gave you, in the city of Irving.
Okay, that's the defendant's address or your address?
That's my address.
Okay,
Where I
and
saw
the
it from.
defendant's address would be what?
Hers is 810. Mine's 808.
Hers is 810 and yours is 808, Jane?
Mm-hmm.
Okay.
So mine's 810, and she lives over at 808.
Okay. And the video that you've presented here in court shows the 808 address, correct?
Yes.
And the video was taken from the front of your home at 810, correct?
Yes.
Okay. And do you know what direction that is? North, south, east, west?
No.
So,
Okay. So the video camera faces south toward
correct.
the defendant's address.
Yes, that's right.
Okay. And what time of day is depicted in the video? What time is this?
Evening, little left before dark,
Dark.
or just it was dark out, about 9 o'clock.
Is it an infrared camera?
Yes.
Yeah, not vision.
The video's infrared. It's not regular
No, it
video.
has night vision.
So it is infrared,
It is, if you want to call it infrared.
which means you can't see features or colors.
You can see features. It's not red. It's you can see plain people. It's just got.
I didn't say it was red, Jane. I said that night vision on cameras is done via infrared, which means everything looks like white
No, it's all clear.
and different shades of white. Then it's not night vision, and it's not dark.
It's completely dark. So
Okay.
I have night vision on my cameras that shows that lights up everything with I guess the ambient light that the camera maybe provides. He has a spotlight on her cameras.
Well, that's a different thing, isn't it, Jane, than infrared?
Yeah. Well, I didn't bring it into the
In any case. Okay, do you have what you need now, Jane?
No, probably not, but still, okay, so but there still has not been any testimony about damage or anything like that. So I really don't I reserve the right to bring this witness back. I'll pass on this witness reserve the right to bring him back.
I preserve the right to recall the witness.
Okay. I preserve the right to recall the witness.
Noted.
Okay, so she's dismissed, right?
Are you done?
I am. With her until she comes
Judge,
back.
The witness is
Prosecution.
excused.
The
Oh.
prosecution would like to call Officer Delgado to the stand.
Officer Delgado?
Who wants to play Delgado?
I'll do it if no one else wants to.
There you go.
Okay. Officer Delgado, please give us your name and your job, please.
Yes, Nathali Grimaldo Delgado, and I'm an animal control officer.
For the city of Irving.
City of Irving, yes, that's right.
Okay. And how long have you employed as an animal control officer?
4 years now.
And in that 4 years, have you had training on how to properly do your job?
Yes.
And when was the last training that you attended?
4 years ago.
4 years ago, you said?
Yeah.
Okay. And what exactly is the training that you received? Just a summary of it. You don't have to go into great detail, but what kind of things are you trained on?
I'm trained to the proper way to respond to calls, so I know how to handle them. I know what animals I'm looking for, how to control the animals once I do get them, just to be safe. I like to keep the safety for the public.
And are you trained on how to recognize dangerous animals?
Yes.
And part of your duty is to do what with those animals?
I'm supposed to write complaints if I observe that people are violating the law.
No, I'm asking what specifically is your job relative to the animals themselves? What do you do with dangerous animals when you see them?
It would depend on the animal, but we'll try to catch the animal. It will either discard of it or destroy it.
I'm not gonna say objection. I think.
Okay. And on the date in question, which was what I say, August 27th or something like that, 2024. Okay. Whatever the date was, I said when she wrote the complaint. Jane, do you remember how many days after she wrote her statement that they came back out? Was it the same day, next day, what?
Smith went out there on the 20th of March, and then they wrote the citation on the 23rd of March.
Okay. So, Officer Delgado, are you familiar with the defendant in this case?
Yes, I am.
And how are you familiar with the defendant in this case?
Because we've had multiple complaints.
About this defendant?
Before. That's right.
Okay. And did you have an interaction with the defendant on about 3 days after Miss Smith complained of her feeding animals outside?
I don't recall.
The day you wrote the citation.
So yes, I did. I gave her a citation that day.
Okay. And would this be a copy of the citation that you gave her? Just say yes.
Yes.
And on this citation, you alleged that she was feeding animals outside in violation of this ordinance, correct?
Yes.
And have you ever issued a citation like this to the defendant before?
I don't recall.
No.
No, I have not.
Not her.
Has your department or your agency ever issued a citation like this before to this defendant?
Yeah, according to my system, they've had to issue her complaints before.
Objection, Your Honor. Motion in limine. In effect.
Denied.
The judge overruled your motion in limine.
Oh. Okay.
However, there's still an objection to be made. You just don't know what the hell it is, do you?
Oh yeah, objection because prior acts and testimony and prior conviction is not relevant to this case.
Objection, relevance, and prejudicial.
Okay, okay. Objection, relevance, and prejudicial.
I'm going to give her that one.
I'd like to respond.
Okay, go ahead.
This is highly relevant as it shows that the defendant has a history of violating this ordinance. It also shows that the prior acts establishes the purpose of the defendant to act willingly and knowingly in violation of the ordinance.
I'd like to respond. Your Honor, prior acts are not admissible in the proceedings before the court right now.
I didn't ask anything about the acts themselves, Judge. I just asked if they had ever issued her other citations for the same thing before.
Prior convictions are not admissible.
I didn't ask anything about prior convictions either.
Prior citations are not admissible.
I didn't ask to admit them.
Okay, so why are we bringing it up then?
To establish a pattern of behavior by the defendant.
Prior acts cannot establish the pattern of behavior of the defendant.
Prior act can most certainly establish a pattern of behavior.
On what basis?
Because they show a pattern.
That's total bullshit. You know it. What about the witnesses pattern? Not mine. Let's see. It's
Jane, stick to your role.
Improper character evidence.
Judge, we didn't mention anything about the defendant's character. We simply asked the officer if they had issued citations for the same offense to the defendant before.
I'm gonna allow.
Okay, now, Officer Delgado, on the day in question, you issued this citation to the defendant for feeding animals outside. You testified that that is correct, right?
Yes.
Okay. And what else did you notice while you were on scene interacting with the defendant?
With the defendant,
Just in general, what else did you notice or have reason to observe?
she was uncooperative at times.
Uncooperative in what way?
She was trying to argue with me, didn't believe she deserved the complaint.
The citation, you mean?
The citation, yes.
Objection, Your Honor.
And in your experience, do people you issue citations to often argue that they don't deserve it?
Yes, a lot of times that people feel that they're not in violation, so it's pretty regular for that to happen.
Objection, Your Honor. Relevance.
And what else, Jane?
Also, I'm saying unfair prejudice, Rule 403. I'll give you values that way by Dodger.
Objection. Hearsay and relevance. I asked about what somebody else said, Jane. That's not admissible.
Yeah, you're right.
Pay attention.
I was too busy trying to find the objection.
Exactly.
Yeah.
The objection, Jane.
No, hearsay is not admissible. Objection.
Sustained.
Okay. Now, while you were there, did you see the food plates on the ground?
Yes.
Objection, Your Honor. The officer didn't witness anything because it didn't come up to the property.
Okay, no, I did not. I just issued her the citation.
Yeah.
Were the plates visible from the location you were standing?
No.
No.
Okay. So you didn't personally witness the plates on the ground?
I didn't personally, but there was a video made that shows the plates clearly on the ground.
Yes,
But-
we had the prior witness testify to the video. Okay. And in that video, which you would have been in the hallway, would not have been able to see. Okay.
Okay.
So, given that, Judge, I would like to once again have the officer look at the video that was submitted by Mrs. Smith in this case. And in this video, officer, do you see the defendant walking out of her home carrying what looks like 2 plates and set them on the ground? And these cats come up to the plates showing that they must be full of food?
Yes.
Okay. And from where you were standing on the day in question, could you see that location
See the location.
where
Yeah.
she set down those plates?
Objection, Your Honor. The officer did not do any kind of investigation. Wasn't been able to see anything.
Again, Judge, I simply asked the officer if they could see the plates in question from the location they were standing.
No, they could not.
No, I couldn't.
Overruled.
The evidence doesn't show that either.
The evidence doesn't show where the officer was standing, Jane. They weren't there the day the video was taken. That's kind of the point. That's why I asked if on the day in question they could see where the plates had been set down.
And that's why I say objection, because the officer did not do any investigation. So therefore he wouldn't know where the plates
Well,
were.
then you get to ask that when it's your turn.
Okay.
Okay?
Objection is overruled.
On the day in question, could you please tell us how many animals you saw at the defendant's location?
On the day in question, I didn't see any animals at that particular moment.
Okay. And did you happen to see if there were any food bowls out at the time?
No, I did not.
Okay. And did you talk to Mrs. Smith at all when you arrived that day?
No.
Yes, no, I did not.
Okay. So you, what did you do when you arrived on scene?
I approached Lynch, and then I issued her a citation for the offense.
Okay, the citation that you're looking at there in your hand.
Correct.
Okay. All right. Judge, we're done with this witness.
Okay. Call your next witness.
Nope. I get to cross.
Oh, sorry.
Okay.
Defense.
Okay, well, I'm not going to go over all the training information, but maybe I should, but I didn't get to scribble down as fast as y'all were talking about it. But,
Well, you've only got 8 minutes.
great. So, officer, you said that you observed plates and what the location of the plates would have been left from.
Jane, we can't hear you. Speak into your mic.
You just testified that you were able to see the location where the plates were left by the respondent.
No, he said he couldn't. The witness testified they could not see.
I thought he said he could. Okay.
You said he couldn't. Therefore, we're going with that.
Okay. So, officer, did you observe any animals? Any animals?
Objection asked and answered.
Sustained.
Officer, did you witness any? Let's see what's that. On the day that you wrote a citation, are you testifying that you did not do any sort of investigation?
No, I'm not.
Objection, lack of foundation.
Sustained.
Okay. What? No, I can't even ask you about anything. I'm supposed to be asking questions about what the prosecutor asked, right? Or what they responded to exactly.
You start there. You have to start from something that's already been testified to, Jane. You don't get to start out in left field if nothing in left field was ever asked.
So, Officer Delgado, what was the reason you came out to defendant's property on March the 23rd?
I issued the defendant a citation.
Based on?
My investigation.
What investigation?
The complaint that we had received.
Okay, well, the complaint doesn't, you're talking about the statements written by the complainant witness?
Yes, we had had a report.
Did you not?
It was based off.
Do you not know what the ordinance is that the respondent is being charged with?
I know the ordinance.
Did you not verify in the ordinance the allegations made by the complainant?
I was going by what I was told during my investigation.
So what was the what is your evidence that what the actions of the respondent caused a danger to public health and safety, for one?
Mrs. Smith said that she had a video.
Okay, but you saw the video and you didn't see evidence of any.
Objection. Is the witness testifying as to what, or is the defendant testifying to what the witness saw or didn't see?
Okay, how many animals did you see in the video?
Sustained.
I thought I haven't seen the video yet, right?
I thought they already put the video on the evidence.
I played it for you when I was talking to you.
Okay.
Uh-huh.
Yeah, I saw 3 animals in the video.
Okay, 3 animals does not make 10. Is there? There's no
Objection, Judge. Is the defendant cross-examining or testifying?
Okay, so you have
Sustained.
you have no evidence that there's ever been 10 or more animals eating the same.
Objection, Judge. Again, the defendant is trying to tell the witness that they do or don't have evidence. The prosecution is the one that has to present the evidence, not the witness. The witness simply provides testimony or testifies to the evidence.
Sustained.
This is not how this is going to go. I know for a fact it's not going to go unless I'm.
If you keep asking questions the way you are, it's how it's going to go.
The whole thing is not going to go like this. So,
Jane, you're testifying, hon. You are testifying. You're From where you're standing, you're testifying to what you believe happened.
If I
You can't do that.
If I can't
You
ask
have to.
related to
You're-
what says in the ordinance and the violation, then how am I supposed to get the judge to take judicial notice of the ordinance itself? If I can't
First of all, you don't testify.
Okay, stop,
I
everybody.
don't testify.
The problem, Jane, is how you're asking your questions. That's the whole problem. It's always been the problem.
I'm not asking direct questions. I'm asking leading questions.
But you're not asking the right leading questions. That's the problem.
But this is not going any of the way that you trained us to do this. This is not at all, because I was able to ask about the manner of feeding. Did you capture any of these animals? And then now anything that I asked, you're going to say that it's not been any foundation. So I don't know how I'm supposed to get what was actually in our
Well, since you're out of time and I get to play you now, I'm going to show you.
Please. Okay. Yeah, I'm not ready for this. I might as well go ahead and plead guilty.
No pleading guilty.
Now, would we like to simply assume that the prosecution has done the same job that I did with the witnesses so far? And let me clue you in. I did a piss poor job as the prosecutor in this case because I don't have any questions I can actually ask from the witnesses I've got so far. Because I know if I ask the questions I have to ask, I'm going to prove they don't know anything. So I can't ask them everything I want to ask. All right? And we haven't called the third witness yet because Jane drug her feet on getting us there. Okay? So real quick, I'm going to run through this as Jane, starting with assuming that I was able to get in all the questions. So let's see what I would have asked as a prosecutor if I'd been trying to get this in and everybody knew what they were supposed to know. I would have asked the questions about the officer coming out, the officer observing the video from the neighbor, the officer taking the neighbor's statement and delivering it to their boss telling them to go back issue a citation based upon the statement and the video, the officer coming out and issuing the citation based upon the directive of their supervisor. Okay? And then I would have asked the supervisor when they got on the stand, does feeding animals outside create a danger to public health or safety? They would have testified, yes. It can attract rabid animals. It can attract sick animals. It can create all kinds of problems. It can also lead to destruction of public or private property because of a gathering of animals. And oftentimes when you leave food out, it will start to gather many different kinds, or many of the same kind of animal, which is a big fear this time of year because of rabies and other things. That would have been what they would have gotten up there and testified to as far as the two animal control officers go. Everybody clear on that point?
Yes.
Okay. Now, had I been Jade in those situations, this is how I would have handled each of those as they happened. Okay. Mrs. Smith, are you a licensed veterinarian?
No.
Have you ever been a licensed veterinarian?
No.
Are you a veterinary assistant?
No.
Are you a veterinary clinician?
No.
So you have absolutely no knowledge, experience of any kind on animal diseases, behavior, or recognizing when an animal is ill.
I've had animals my whole life, so I know that I can tell.
You would know how to tell if a wild animal is ill or not?
Yeah, by the way they act.
Really? So you are an animal behaviorist. Based on what experience?
I'm not certified, but...
Actually, Smith has never owned any animals. She hates them.
Okay, so no, I'm not.
Okay. So then the video that you put up doesn't show anything that would prove one way or another whether the three cats that are in it are in any way ill, correct?
Correct.
And you have no frame of reference for determining whether or not any of them are ill, correct?
Correct.
And you have no expertise or experience in that either, correct?
Correct.
You didn't examine any of these animals, correct?
Correct.
And even if you had examined them, you wouldn't know what you're looking for, would you?
No.
And if you had handled an animal that you didn't know, would you expect to get bit?
Possibly.
Okay. And if you initiated the contact with the animal that resulted in the bite, that would be your fault, wouldn't it?
If I initiated it, but they're coming over onto my property, coming towards me.
That's not what I asked you, Mrs. Smith. I asked you that if you initiated contact with an animal you don't know and wound up getting bit, that would be on you, wouldn't it?
Yes.
Okay. Now, did any of the 3 cats that you see in this video attack you at any time?
No.
Did any of them come over and shred any part of your property?
Not in the video, but it has happened before.
And what is your evidence of that?
They destroyed my plants and some of my decorations.
Did you bring those plants with you?
No.
Did you get fingerprints from the cats to prove that these cats are the ones that destroyed your plants?
No, I did not.
Are these plants sitting outdoors?
They are.
So they're accessible to any cat or any other animal that may happen to travel through that area, not just these 3 cats, correct?
Yeah, correct.
And you don't have any video showing that any one of these cats specifically is who vandalized your plants?
I don't have video, but it has to be them because she tracks all the animals.
Objection, speculation.
Sustained.
You don't have any actual evidence to present to this court showing that any of the 3 cats in this video are the cats that allegedly destroyed whatever plants you're talking about. Do you?
No.
Okay. And the statement that you wrote and submitted, the statement doesn't accuse me of committing any crime. The statement reads more like a personal bitch session by you about how you don't like me and what I do. Would that sound about correct?
I was just stating facts. I wasn't bitching.
There are no facts stated in this other than I don't like what she does.
I don't know who the prosecutor is, but they're not doing a very good job.
What's the
Well,
prosecutor
clearly
going
out
to
there.
object to at this point? This would all be stuff that they would have gotten them to testify to.
Like try to similar
Prosecutor's done, Jane. This is just you. Afterwards.
No, the prosecutor will be objecting to things that I'm asking the witness.
And I'd
If
be
you
shooting
covered
them
all
down.
the bases, prosecutor covered all the bases. We're not touching on anything the prosecutor would not have asked about.
Well, the prosecutor is not trying to let the evidence in that there is not a danger to public health and safety or property damage. Or any
Jane, we laid the foundation by asking about the video and what it shows.
Yeah,
From there, we can go to anywhere else that connects to it, Jane.
I couldn't do it. You can, but I couldn't. So go ahead.
That's right, you couldn't because you didn't ask a question that would get you there. You always started at that question without laying the foundation. That's the problem. Connect the dots, not jump to a dot in the fucking middle.
Well, can you kind of do it like you did it before in our practice? Instead of changing it every time we do it? To like totally asking all different
We
kinds.
change it so that you can see the different kinds of situations you're liable to encounter, Jane, to
Okay.
teach you how to handle them. They're not going to be cookie cutter.
Okay. Go ahead.
All right. Where were we? All right, so Mrs. Smith, you didn't actually see any of the animals in this video that are allegedly being fed by me. None of them attacked you to create a danger to your health or safety, correct?
They didn't attack me, but they scared me at times.
Are you often scared by animals?
Yeah, when there's a bunch of wild animals that she keeps feeding, I am.
Well, what is your evidence that these are wild animals? They seem to be sitting pretty calmly in the video. They don't seem to be attacking anybody. They don't seem to be afraid of anybody. What is your evidence that they're wild?
Because they climb all over my cars and all the neighbors.
Well, that's just your opinion. That doesn't make them wild. That makes them a cat.
Actually, she chases them down and screams at them.
Yeah, they're just feral cats. I've never seen her. They're feral.
So you think they're feral?
Yeah.
Okay. So, based upon that testimony, you don't know that I am an owner of these cats.
No, I don't know for sure, but
You just see me feed these cats from time to time, correct?
yes. But if you wouldn't feed them, they wouldn't be around here.
Objection. Please answer the question I asked, not your opinion on anything else.
Yes, I do.
Sustain.
Okay. All right. I believe. Oh, by the way, you have this camera pointed at your neighbor's house. Why?
That's just how the camera faces because it faces south.
But you have the camera facing directly at your neighbor's house. Right at her front door, in fact, correct?
Well, that's how it's set up, yeah, because it's covering my front yard.
No, it doesn't. It doesn't even get her front yard. It only gets my yard.
Okay, yes, I do have it. It's facing her towards that way, but I just want to protect my side of the house. That
You're not getting any video from your side of the house. So.
Okay. And have you submitted video to the animal control or the police before about your neighbor?
no, but I've called many times.
Based upon something you see in the video?
I had the video and with my own eyes.
Okay. So you're actually using your video system to surveil your neighbor.
You could say that.
And for how many years has this video been in place? This camera?
Since 2019.
About 6 years now.
So for 6 years, you've used this video system and these recordings to constantly report your neighbor for things and have the cops come out and harass her.
That's not the only reason I'm having cameras there, no.
But you use it for that quite regularly, don't you?
I see that stuff on those cameras, yes.
And you report it not because you think it's wrong, but because you don't like it, correct?
Oh, it's wrong, and I don't like it either, but it's wrong. It's creating a nuisance.
That's your opinion.
Yes, and the rest of the neighborhood.
But she's never been arrested based upon the things that you've reported, correct?
No one else in the neighborhood has this event.
I'm not aware if she has or not.
Okay. Well, Judge, that's all for this witness. She hasn't offered anything worthwhile to the facts of the case, other than to prove that she hasn't suffered any property loss or damage or been endangered by the animals, and that she just never witnessed more than the three in the video at any one time. So the defense is done with this witness.
Alrighty, does the prosecution have anything else for this witness?
Now here the prosecution would have the opportunity to redirect to get the witness back on track to support their case. Assume that they've attempted to do that. Okay? And the best they could have done, based on what they know, is you saw the defendant feed these animals outside on a regular basis, day and night, correct?
Yes.
Okay. And you complained that they were also coming over and destroying your property, correct?
Yes.
All right. But you don't know how many there ever actually were at any given time, but they did come over and destroy your property. Do you happen to have any health issues relating to cats or other animals?
I'm allergic to them, yes.
And have you interacted with these animals because of their presence?
No, I just see them there all the time.
Okay. All right, that's all.
Witness is excused.
Now,
Any
Officer
further
Delgado.
witnesses?
Officer Delgado would have been called to the stand. Jane would have had to do her cross on Officer Delgado. So, let's go through what I asked Officer Delgado as Jane. Okay? Officer Delgado, you testify that you've been an animal control officer for X number of years at the City of Irving Animal Control office, correct?
Yes.
And you said that the last training that you've attended was 4 years ago, which was the time you started at the Animal Control Office, correct?
Yeah, that was the last training, but I do this every day, so I'm a professional at this.
You do what every day?
Animal control officer. I deal with the nuisance animals.
Okay. So you're a professional animal control officer. Are you a certified licensed veterinarian?
No. No.
No.
Are you a certified licensed animal behaviorist?
No.
Not certified, no.
Have you ever worked as a veterinary clinician or as a veterinary assistant?
No.
So your professionalism relates strictly to chasing and catching and issuing citations, correct?
Yes.
And that's all you really do, correct?
Yes.
And the citation that you issued to the defendant in this case, the prosecution showed you a copy of that. Now, could you please look at that and once again remind us of what it says? And all it says is fed an animal outdoors in violation of 680-E of the ordinance.
Yes.
Okay. All right. Now, I take it by the fact that you made reference to 680-E that you are familiar with the ordinance.
Yes, I am.
And you've thoroughly read and understand that ordinance.
Of course. It's my job.
The defense would ask the court to take judicial notice of 6-80 of the City of Irving Code of Ordinances. Okay?
Noted.
Now, I would ask the court to please allow me to hand the witness a copy of the ordinance as taken from the city's website.
Go ahead.
Okay, now, Officer Delgado, could you please read the first sentence of the first paragraph right under where it says Section 6-80 Animal Nuisances? And that'll be what's on the screen here at the very top.
Yes. The owner of any animal in the city is responsible for the behavior and conduct of that animal. Hold on, I gotta make it bigger. Okay, at all times, including conduct that creates a public nuisance. A person commits an offense if by act, omission, or possession, she allows an animal to create a public nuisance. The following are a public nuisances.
Okay. Now, the public nuisances are the animals at large, a person, and the person commits an offense if they permit animal waste to accumulate. A person commits an offense if she or he allows her animal feces to remain in any public place or on another's private property. A person commits an offense if he or she owns any animal that makes or creates an animal noise disturbance of any type in such a manner that disturbs, distresses, or annoys a person of reasonable sensibilities, or the things that are in E, which are the things that are alleged in the complaint. Everybody understand what the ordinance directs here?
Yes, sir.
They are charging her with subsection E and only subsection E. However, the first paragraph contains two predicate elements. The person must be an owner of the animal, and the person must have created a public nuisance because of the animal's conduct or behavior. Got it?
Yes, sir.
That's the predicates. Now, once we're down to E, a person commits an offense if he or she intentionally feeds any animal or makes food available for animal consumption in a manner that either creates a danger to public health or safety, destroys public or private property, or causes more than 10 adult animals to congregate in one location at the same time. Now, Officer Delgado, you say that you've issued citations to the defendant before for feeding animals outdoors.
Not me personally, but our department has, yes.
Okay. Well, I won't get you to try to testify to something that someone else in your department did, but on the day in question, you did issue a citation, correct?
Yes, I did.
And the citation alleged an offense under 680E, correct?
That's correct.
Okay. Now, did you issue the citation based upon your personal knowledge of each of the elements of 680-E? And let me give you a specific example of each one, and you tell me yes or no to each one, okay?
To my personal knowledge or what I was told during my investigation?
I want you to tell me your answer based upon your personal knowledge and the question that I ask on each one of these. Do you understand?
I do, yes.
Okay. 680-E or 6-80E says, a person commits an offense if he or she intentionally feeds any animal. Did you, at the time you issued this citation, witness the defendant feeding any animals?
No, I did not.
Okay. Did you witness the defendant making any food available for animal consumption?
No, I did not.
If you did not see them feed any, or see the defendant feed any animals, and you did not witness the defendant making food ready for animal consumption, then you did not witness anything that would constitute the creation of a danger to public health or safety, did you?
I don't recall.
You don't recall. Either you did or you didn't. Did you or didn't you?
No, I did not.
And you didn't see any animals destroying public or private property, did you?
No, I did not.
And you didn't see more than 10 adult animals congregating in one location at the same time at the defendant's residence, did you?
No.
So you do not have personal knowledge of anything that would be a violation of the ordinance, correct?
No, I don't. But would you have video?
In fact, you don't have any evidence that the defendant is even the owner of the animals that are in the video, do you?
No.
So everything that you put into that citation was entirely speculation on your part.
I concluded my investigation. That's what I concluded.
According to you, there was nothing to investigate. There was no feeding. There was no witnessing of feeding that created any of the things listed in 6-80E 1, 2, or 3. So what did you investigate?
We had a complaint, and I was just doing my job.
You based the citation solely on a statement written by Mrs. Smith. And that's all, correct?
Yes.
But there's nothing in Mrs. Smith's statement that alleges any of this in the ordinance ever happened.
Correct.
There's nothing in the statement that says the defendant owns the animals, correct?
No.
There's nothing in the statement that says she intentionally feeds the animals with the intent of creating a danger to public health or safety, is there?
No.
There's nothing in the statement that says a danger to public health or safety even existed, is there?
No.
There's nothing in the statement that said that there was a destruction to public or private property of which the person making the statement had firsthand knowledge, is there?
No.
And there's nothing in the statement that said that there were ever more than 10 adult animals congregated in one place at the defendant's home
No.
at the same time.
No.
And the video provided in accompaniment of that statement shows that nothing in that statement appears in the video. Correct?
Correct.
So in other words, your so-called investigation was based upon complete bullshit.
I can't confirm or deny.
You can't confirm or deny. You said you didn't see any of these things. You never witnessed any of it. And your investigation was based solely on the statement made by Mrs. Smith and nothing else.
Yes.
So you are confirming that is what you did.
Yes.
Thank you. Nothing else for this witness. Now let's also assume the supervisor got called. And the supervisor testified that it is common in the state of Texas for animals at this time of year that are fed outdoors to be contacted by wild animals that can carry disease that might infect them with rabies or other types of parasitic diseases, etc., etc., etc. Therefore, we admonish residents not to feed animals outdoors, and we issue citations whenever we see someone doing it because we wish to keep the public safe and keep them from animals converging on the neighborhoods and attacking people and destroying property, etc., etc., etc. We can assume the prosecutor got all of that out of whatever the supervisor's name is. What is it?
Hollinger.
Hollinger?
Hollinger.
Hollinger with an H.
Hollinger. Hall with a Hull.
Hollinger. Okay. All right. So, Officer Hollinger, or Supervisor Hollinger, how would you like to be addressed?
Officer.
Okay. Officer Hollinger, you received the statement by Mrs. Smith at your office, correct?
I did. We've had multiple statements from her. This is a
Please answer the question I asked you. You received this statement relevant to this case from the accused at your office, or from Mrs. Smith at your office, correct?
I did, yes.
And you got a copy of the video that's been shown in this case at the same time from Mrs. Smith, correct?
Yes. It clearly shows Mr.
And did you view the video when you received it?
Yes, I did.
And what did you see in the video? Did you see 3 cats, 2 of which approached the defendant when the defendant brought something outside and sat it on the ground?
Yes.
And did you ever see anything in the video where there were more than 3 cats present?
No, I did not.
Okay. And you didn't see any other human beings in the video other than the defendant, correct?
Correct.
So you did not witness those 3 cats attack anyone, correct?
No, I did not.
And are you by any chance a licensed veterinarian?
No, sir.
Are you an animal behaviorist certified and all?
No.
Have you ever worked as a veterinary clinician or assistant?
No.
Okay. So you have no way of diagnosing an animal's health either, and no certification on how to do so, correct?
No.
So if you wanted to test something for rabies, you would have to send the animal off to a veterinarian to actually have them tested to determine if the animal had rabies, correct?
Correct.
So you wouldn't know just by looking at them. You could only speculate, correct?
That's right.
And are you familiar with how any particular type of animal behaves when they're infected with rabies?
They tend to be aggressive, yes.
Have you ever personally witnessed an animal infected with rabies? Yes or no?
Not personally, just on YouTube.
Therefore, you have no personal knowledge of what any particular type of animal may behave like. In other words, a raccoon may behave differently than a cat.
Yes, that's right, correct.
And a cat different than a dog.
Yes, correct.
And all of those different than a cow.
Yes.
Okay? So anything that you would have to say about whether they were ill or not would be completely speculation on your part.
Yes, that's right.
Okay? Now, what evidence do you have to show that the defendant is the owner of any of the 3 cats in the video?
We've witnessed the cats we've been up called out there many times.
Objection. I didn't ask where you had seen the cats. I asked what evidence you had that proved the defendant is the owner of the cats any of the cats in the video.
They're regularly on her land. We know that she owns those.
Is the fact that an animal is on someone's land indicative of ownership?
No.
Then again, you're speculating, aren't you?
Yeah, we've had multiple complaints on the neighbors.
So you have no actual evidence that the defendant is the actual owner of any of the cats that are shown in the video?
No.
And you have no other video or photographs of any other cats at the defendant's residence, correct?
Correct.
Okay. Now, based upon your lack of experience as a veterinarian, the ability to diagnose animals as being ill or anything of that nature, and the fact that you were never personally present when this video was made and never inspected these animals and never interacted with these animals, you have no first-hand knowledge about anything in this ordinance, correct?
No.
Because, let me follow through with this now. Let me just go through it one by one. We already determined that you have absolutely no evidence that the defendant is the owner of any of these animals, correct?
Correct.
And we have no evidence that you submitted or testified to showing that the defendant intentionally fed these animals for the purpose of creating a danger to public health or safety. You have no personal knowledge that that's why she did it, right?
No, we just know that she feeds them regularly.
And you have no personal knowledge that her feeding them did create a danger to public health or safety, correct?
Only that we've had complaints and the neighbors are fearful.
Objection. Please instruct the witness to answer the question I asked, Judge.
The witness will answer the question.
No.
Yes or no, Mrs. Hollinger?
No.
You have no personal knowledge that the defendant's feeding of the animal was intended to create a danger to public health or safety, correct?
That's correct.
And you have no personal knowledge that her feeding of these animals did create a danger to public health or safety, do you?
No.
And you have no personal knowledge that any of these animals are responsible for any destruction of public or private property, do you?
Only what the complaints we've had.
Again, please answer the question I asked. Yes or no?
No, I do not personally know.
And you have no personal knowledge that 10 or more adult animals have ever congregated on the defendant's property at the same time, do you?
No, I do not.
In other words, you don't know a damn thing about what happened, do you?
I know what the complaint says, and I know that this is...
Objection. Non-responsive.
The witness will answer.
We've had multiple complaints, as I mentioned. This
Objection. Again, not what was
Sustained.
asked, non-responsive.
The witness will answer.
You have no personal knowledge of anything that violates the ordinance, do you?
No, I do not.
So your testimony is complete bullshit, isn't it?
No.
I thought you were going to say that.
I told you, we've been getting complaints.
Again, you've got no complaints that substantiate anything in the allegation against the defendant. None. You have no personal knowledge of a single thing in those complaints. And you just testified to that.
Yes.
You're not a field officer, are you?
No, I'm not.
And you did not go out on any of these so-called trips to the defendant's property, did you?
No,
And you never personally witnessed anything that occurred.
I did not.
And you never personally issued any of the citations.
Not personally.
And you never personally conducted any of the investigations.
I did not know.
And obviously neither do any of your officers. Therefore, you're here to testify to everything you don't know and have no personal knowledge of. Correct?
I have no personal knowledge, no.
Okay. Then I move that all this witness's testimony be stricken from the record, Judge. They testified they have no personal knowledge of anything they testified to, and the prosecution, by asking them to answer these questions, has attempted to suborn perjury in this case.
It is so ordered.
Okay, Eddie, can you go ahead and do a recross of him as if they had submitted all the evidence of Smith? Because we haven't done that enough.
He just got knocked out of the whole trial. There is no recross.
I'm talking about, can he provide a cross as if Smith actually had, they had admitted her evidence and stuff.
I just did that, Jane. I just asked them about the statement. I just asked them about the video.
I'm not talking about the officer. I'm talking about Smith.
We're on the
I asked
officer,
Smith the same shit, Jane. I asked Smith about both of them, too.
Well, you didn't ask.
I crossed Smith right before I got to Delgado. Then I went from Delgado to Hollinger.
No, but you didn't already ask Smith anything.
Oh, yes, she did. You got to go back and listen, man. You got lost somewhere.
Okay.
I made Smith admit to everything that she put in that statement was complete bullshit. I made her admit that everything in her video was complete bullshit. And you missed all of that? What, you have to go to the bathroom or something?
No. Anyway, okay.
Now, how long did that take me? 41 minutes from 10 after, so 31 minutes.
And left them all in flames.
Well, you've been doing this for how long? 20 years?
Jane, everything you need is right here tonight.
I know, but I was supposed to do it, but I couldn't do it. So there you go.
You're going to have to do it, ma'am.
Again, Jane, as I've told you, The only thing you need to worry about is showing that they have absolutely no personal knowledge, none of them, of any. Shut up and listen. They have no personal knowledge of a single damn thing to prove what's in this ordinance. None. None of them do.
Well, you absolutely had nobody objecting to what you were asking the witness either.
Because I laid foundation for everything. I based everything I started with on what they'd already said to the prosecutor. I didn't jump in the middle anywhere. I led them right down the path I wanted them on, step by step by step. I laid the foundation for everything. Does anybody listening to what I asked have any objection to how I asked it to say I didn't lay foundation for something I asked?
Absolutely not. It was brilliant.
Agreed.
And I even did a couple of Columbos. Oh, just one more question. Let's back up for a second. I need to ask you this. Because they opened the door and gave me the opportunity to go back to it. This goes to what I keep telling you guys about listen to what you hear. Okay? When you listen, you analyze. When you analyze, you pick up on things. You can tell what they say and how they say it. And then you can determine whether or not it's useful and make a note of it. And then, that's why lawyers always keep pads in front of them when they're sitting at their table, even when they're asking questions. If the witness says something they want to be able to come back and address, but not lose track of where they are, they write it down on their little notepad. And then when they're done with the questions they've got right now, they'll circle back to what they wrote down. And then they will beat the witness up over that. That's exactly what I did for all three of these witnesses. I took what the prosecution would have asked them. I even restated everything the prosecutor would have asked in order to get the evidence they need to try to convict you. The problem is, everything that these people would have testified to would have been complete bullshit. And the prosecution knows that. They're counting on you not knowing that. But we do. We know they have to prove what is in the elements of the ordinance. And they could not have given any testimony that did that because none of them have personal knowledge of any facts that could do it. And that's all we needed to do was to get them to admit on the record they don't have personal knowledge of any of this shit. None of them do. Not even Smith. And now, once the prosecution gets done with their redirect and says the prosecution rests, what do? Judge, I move the court for a directed verdict in favor of the defense. The prosecution has failed to prove its case. They have introduced no evidence or testimony in support of the elements of the alleged offenses within the ordinance.
I agree. So ordered.
That's it. 31 minutes. This is why you don't have to object to every single thing they say unless you can show that what they just said is a lie and you aren't going to address it when it's your turn to cross, but you need it in the record that that's a lie. You need to make a note to address it, and you need to object to it. Objection assumes facts not in evidence. If they're going to lie about about what they know, then you have to make them admit that they lied. And that's what I did when I crossed and said you were not there, you were not present, you based everything you did on the statement of Mr. Smith and on the video from Mr. Smith. That was your sum investigation, your total investigation. Correct? And that's what both animal control officers had to base everything they said or did on. Because they didn't do anything else. This is why I told you that all the things you keep trying to get Smith to talk about, Jane, you don't need to win your case. I just threw them in there to humor you a little bit, to make you feel better about the questions. But the fact is, I didn't have to ask a damn thing about whether she likes you or not to win. I just did it to emphasize the point that her testimony is unreliable, even if it was true. Now, who's got a problem with the way I did it? Asked Jane.
Jane just needs to realize you don't need.
Heidi, you need to, you're breaking up really bad. Get closer to whatever you're talking on.
I said Jane needs to realize that she doesn't need 90% of what she's worried about.
No, that's a point I've been trying to make to Jane for a while now.
I didn't get to cross even do any 5% of what I was trying to question about, just about even about the ordinance. So,
that's because you're dragging your feet. You're trying to come up with stuff that you think you need when you don't.
When I came up with this, questions about the ordinance, I wasn't allowed to even question that. So I didn't get to really.
Because you didn't lay the foundation to get there, Jane. That's the thing. You still have to follow the rules of getting to where you need to go. I wanted you to make those mistakes so I could show you how to fix them. That's how come I got to ask, what evidence do you have? Because I got them to testify to specific facts, and then I asked them, how do you intend to support that fact? I didn't just jump in and say, well, you don't have any evidence for this, or this, right? And that's what you did. And that you cannot do. You have to ask the question that requires them to provide the evidence. And then you have to question whether or not they have it. Do you understand that path versus the one you used?
I know it's the right way to do it, but...
No, it's the only fucking way to do it.
Well,
otherwise, you get objected to and you get shot down before you can do it.
It's law, Jane. It's not a slumber party sleepover where the girls bitch about it. This is law. It's cut and dried. Leave the other shit outside. Just go with law.
Okay, think of it like this, Jane. There is only one way to travel the trails from the top edge of the Grand Canyon into the Grand Canyon. And you know what that way is?
No, I just fall in there.
Carefully. So that you don't fall in there. Okay? Now, you may ride a burro down there. You may walk it. But no matter which of those two modes of transport you use, you will use them carefully or you will fucking die. So it isn't the vehicle that's the problem. It's the way you use it. So when you're asking these questions, you have to walk the trail very carefully to lay your foundation, get your testimony as a factual statement, and then challenge whether or not that statement can be supported with actual evidence from the person who is making it. That is the only way you will be able to do what you tried to do. If you do it any other way, they're going to object to it, the court's going to sustain it, and you've lost the opportunity. In other words, you've fallen off the fucking trail. Now, you may fall to a different part of the trail, little battered, and all that other kind of shit, and not dead yet, but you keep repeating that kind of behavior, and you're going to hit bottom eventually.
No, I got another be convicted on.
So learn from your mistakes of what you were doing and how you were doing it. And take what I was doing and build upon it. Correct it. Now, let's go. Anybody, somebody else, interject in here. What did anyone else notice about either of us and how we did things? Me as a prosecutor, I know what I had to get in, but I also know that I couldn't ask the witness to lie, though the city attorney might.
I think we did was amazing. If it were me personally in her shoes, I would listen to what that script over and over and just practice it and go in there and talk to him how you did it, because I felt like I got a beat down and I wasn't even the actual witnesses. You did it amazing, I thought.
Okay. Well, the thing is you don't have to do it with the attitude that I use, but when it comes to these people, they piss me off enough that I tend to intimidate even when I shouldn't. I should be more like Columbo. I should always be the humble, nice guy when I do this. If I really wanted to be completely successful at it without creating animosity from the judge, that's how I would do it.
But the way you did it, you left me no outs. There was nothing I could say that unless I were to lie.
Yeah, there's no way that I'll be able to get away with talking to them like that, or even asking questions. It's
But
not
just
gonna
do it in your style, but learn the questions. I would practice those just relentlessly, and he gave me no outs whatsoever.
Yeah, I have on all the other
No.
this, but it didn't work. So I don't know what to say.
He's not going to change his questioning. I think he just means be more the lamb to the wolf. Be more, play a little dumb, you know?
Be more Columbo.
Right. Seem like the scatterbrained guy who just nails it.
Yeah, who's always sounds kind of lost and always looks like he's only just now thinking about these things, when in fact he's had his game plan long before he ever got to where he is. But
Correct.
to the people he's talking to and working on, he just seems like the bumbling detective. And it's perfectly fine for you to look like the bumbling defendant. It makes them think they've won. And you can even play it through. Let's run through this again. Let's take it from the top and assume the same stuff from the prosecution side of things. And I will go back through it as Columbo Jane. Okay? So let's take it from that aspect.
Right.
Mrs. Smith. We'll put Mrs. Smith back on the stand. Now, Mrs. Smith, on the day in question, you were upset by something you observed over at your neighbor's house, right?
Yes, I was very upset.
Okay. And you were so upset that you actually called animal control and made a report, correct?
Yes, I'm tired of this.
And so you also even made a statement and signed a statement for them under oath, correct?
You bet I did.
And you gave them a copy of, I believe, video from your home security system?
Yes, proof of what she's been doing to me.
Okay. And that video, you viewed it before you gave it to them to make sure it was the correct one, right?
Yeah, I made sure of it.
Okay. And the prosecution asked you to talk about what was in the video, and I would like for you to look at, if we can pull the video back up, Judge, I would like the defendant to the witness to take a look at it, and tell me, please, Mrs. Smith, can you tell me exactly what is shown in this video?
Yes, it shows Mrs. Lynch intentionally feeding those animals, creating a nuisance, and coming on destroying the property.
Will you say she was intentionally creating a nuisance? Is that what you feel she was doing, that you personally feel that she was creating a nuisance?
Yeah, because they're wild animals, and they're not any good around here. We don't want them around here.
Oh, okay. They're wild animals. Well, they look pretty tame. They don't look wild to me, but you've seen them behave in a wild manner?
Yes, they've destroyed my yard. I have decorations, and
you've personally witnessed these animals as the ones tearing up your yard?
yes, every day it's some different. They're leaving poop in my yard and feces, and
you've personally witnessed these animals doing this?
I have
the ones that are in this video.
Yeah, they were cats. They're cats doing it.
Are the animals that you're talking about these three specific cats?
Yes.
You've actually witnessed that?
Yes.
Okay. And did you bring any photographs or other videos with you that shows that?
Not with me, but I can see if I have any other thing on video.
Well, the problem is right now we don't have time for you to go back and collect any more evidence. All the evidence that you've had has been submitted, and for now, that is this single video right here. So, my question is you don't actually have any video or photographs showing the 3 cats that are in this video destroying any of your property as in the manner you described, do you?
No, I do not.
Okay. Okay. And by any chance, do you have any documentation in your possession that shows that the defendant is the actual owner of any of the animals in this video?
No documentation, but no, I do not.
Okay. Now, you said that the video shows her intentionally feeding these animals.
Clearly it does, yeah.
Okay. Do you have any evidence that shows that the reason she was intentionally feeding these animals was to knowingly create a danger to public health or safety?
I don't know, but that's what happens when they come around here. I know that.
That's what happens when they come around there? Are you speaking from personal experience?
Yeah, like I said, they keep
Okay,
doing
all right. So if you would, please answer the questions I'm asking you. Thank you so much. So you say that this happens every time animals come around. Are you still talking about the 3 cats that are in the video, or are you talking about some other animals?
Both.
Both. So you once again, you have actual photographs or video that you submitted to the prosecution that they have not yet introduced, obviously, that shows the things you're describing?
I just have the video that I've submitted, but I'm
okay. So you don't have any other videos or photographs that support what you're saying about these other wild animals always coming around and doing all these things, correct?
Not at this time, but I can get some.
Okay. All right. That's sufficient. Thank you. All right. Now, so you just said that they created a danger to public health or safety. What in your mind is a danger to public health or safety?
Being a nuisance to me and the whole neighborhood. They're terrorizing the neighborhood.
But I thought you were the only one that's complained about what was happening in the neighborhood. There are no other witnesses from your neighborhood testifying against the defendant in this case, are there?
Well, some of my other neighbors have complained to me personally.
Objection, Judge. That would be hearsay.
Sustained.
I'm only concerned with what you have personally seen and witnessed, Mrs. Smith. So can you please answer the question based only on what you've seen and witnessed? You have not seen any of your other neighbors file a complaint against the defendant because of these animals, have you?
No, just what they told me.
And you haven't gone down and requested copies of any public records relating to any complaints that have been filed by any of your neighbors relating to these animals, have you?
No.
So you don't have any actual evidence. You just have your personal opinion, that the fact that she's feeding 2 cats outside creates a danger to public health or safety.
Well, I've had to call her animal control repeatedly on her.
Again, Mrs. Smith, please just answer the question that I asked you. You don't have any evidence of that. It's simply your opinion, correct?
Okay, not at this time, no.
Not at this time it's not your opinion, or not at this time you don't have any
I don't have evidence, but they're probably in my yard right now.
And you don't have any evidence, and that what you're saying is based strictly upon your personal opinion, correct?
Yes.
Okay. Now, again, you don't know what the ordinance in question defines a danger to public health or safety as, do you?
I didn't read the ordinance, no, but I know.
So the answer you gave about creating a danger to public health or safety is just what you consider it to be, correct?
Well, so did the animal control. They gave her a citation, didn't they?
Again, hearsay and speculation on the part of the witness. The witness cannot possibly know what animal control or any of its officers thought.
Sustained, the witness will answer.
Well, they agree.
You have no personal knowledge of a danger to public health or safety, do you, Mrs. Smith?
Not personally.
And you don't have any actual personal knowledge that the defendant's intent was to create a danger to public health or safety when she fed these 2 cats, do you?
No.
Okay. And nothing in the video and no other evidence that you've provided to the prosecution at this time shows any destruction of public or private property, does it?
Not in the video.
So, and you haven't presented any other evidence to the prosecution showing that these animals in this video are responsible for any destruction of public or private property, do you?
No.
Okay. And you have no other evidence you submitted to the prosecution that there were ever more animals over at the defendant's residence at the same time than the 3 that you see in this video right now, correct?
No, just my prior complaints.
But again, your prior complaints were never about there being more than 10 animals there. They were about everything else, but they were never about more than 10 animals there at the same time, correct?
I didn't count the animals.
Then you can't say whether or not there ever were 10 or more than 10 animals there, or whether they were adult or juvenile or anything else, could you?
I couldn't know.
Okay. And just so we're clear, you're not a retired veterinarian, are you?
No.
You've never been licensed as a veterinarian?
No.
A veterinary clinician or assistant?
No, I don't even like animals.
Are you a certified animal behaviorist?
No way.
Behaviorist? No, you're not. Okay.
Can you ask more questions about wild animals, because that's what they're wanting me for? I mean, that the thing is creating or causing wild animals to come.
Jane, do
What?
you see the word wild in the fucking ordinance?
Not wild. Just it creates a danger because they're trying to. She's gonna be saying that me leaving food out is attracting animals,
And
other
we,
animals besides cats.
ladies
Wow.
and gentlemen of the jury, did I or did I not just ask all the questions that prove that testimony would be bullshit?
I've heard you ask some of them, but
Absolutely.
Yes, you did. Yes, you did.
There's no need to go there, Jane. You're wasting your time.
You're
Okay.
beating the same horse over and over. Don't dwell on a subject tirelessly. There is no need. Lack of personal knowledge is all you have to establish. Do you understand?
mm-hmm.
There's
No
enough you gotta
personal
learn, man.
knowledge.
Because whatever I said, I can't weasel out of it. You know, there's no way unless you're going to lie.
Okay? Now, we're done with Smith. Let's move back to Delgado and play Columbo there the exact same way. Now, Officer Delgado, on the day in question, you came and issued a citation to the defendant in this case, correct?
Yes, I did.
And the prosecution gave you a copy of that citation earlier. Do you still have that up there with you?
Yes, I do.
Okay, and on that citation, it specifically says that the defendant was receiving the citation because they fed animals outdoors in violation of Section 680E of the Code of Ordinances, correct?
That's right.
Okay, and because you so easily referenced the ordinance on the citation, did you write the citation on the spot, or was it filled out before you got there?
I was already ready to go.
So you filled it out back at your office before you came and delivered it?
Yeah, I made sure that my superior agreed with me. So,
Okay, did you
violating
and
the
your
law.
superior happen to look up the ordinance before you wrote the citation?
I knew that. No, I was doing what I was told.
So your supervisor told you what the ordinance was that the defendant was allegedly in violation of, and you just wrote it on the citation?
Yeah, I explained the situation.
Okay.
And
So you don't have any personal knowledge of what is in the ordinance then?
just what's on the complaint. I read.
You've read the complaint?
Or no, I don't have personal knowledge.
Okay. And you didn't sign the complaint either, did you?
No.
Okay. So, you wrote a citation based entirely upon a directive from your supervisor, correct?
Yes.
You never witnessed anything personally that you could testify to as being a violation of 6-80E, correct?
No, not at this time. We
But
had
the
other.
prosecution called you in as a witness that you did have personal knowledge and had you testify as if you did. But now you're sitting here saying that you do not. I don't understand. Are you saying that the prosecutor asked you to get on the stand and testify to certain things by coaching you to what to say and how?
No, just I don't have personal knowledge, but I conducted my investigation. That's conclusion I came to.
But you've also testified that your investigation was limited strictly to the statement made by Mrs. Smith and the directives from your immediate supervisor, Mrs. Hollinger. The only investigation you conducted was whether or not to follow your boss's instructions because you wrote the citation out before you ever arrived on scene. That is what you've testified to, correct?
That's right, but we've had multiple complaints, so this is the pattern.
But the other complaints are not an issue in this case, are they? Only the one that you wrote this citation for is an issue in this case, correct?
Yes, correct.
Okay, and you have no personal knowledge of anything in the ordinance that you allege the defendant violated. Isn't that correct?
Not personally, no.
So you did not witness any documentation. You don't have copies of any documentation or any admission from the defendant that they are the owner of the animals for which you issued this citation, correct?
No, just what the video shows.
I'll get to the video in a moment. You don't have any actual evidence of any kind, and no matter what its format, showing that the defendant is the owner of the animals, whether they're in the video or any other animals, correct?
Correct.
Okay. And you have no evidence that the defendant was intentionally feeding these animals to create a danger to public health or safety, do you?
No.
Because you weren't present when the feeding took place, were you?
No.
You never witnessed the defendant feeding the animals, correct? Beyond what you see in this one video right here, correct?
Correct.
And in this one video, there are only 3 animals, correct?
Yes.
Can you specifically identify the age of the animals based upon what you see in the video?
No.
No. And just to be clear here, you also are not a licensed veterinarian, correct?
No.
You're not a licensed or certified veterinary assistant or clinician, correct?
Correct.
And you're not a certified animal behaviorist, correct?
No, but I'm an animal control officer. I deal with animals regularly.
And I used to make pizzas for a living. Doesn't mean I'm a bread maker too.
Well, I'm a professional. This is my job.
But does your job automatically qualify you as a animal behaviorist?
Not certifiably, no, but I know what I'm doing.
So it's just your personal opinion as to how good you are at your job?
Yes.
Okay. Well, I'm glad you believe in yourself. That's very important to do when you take a job, is to believe that you can be successful at it. I love a person who's motivated to be successful. Now, you have no knowledge, personal knowledge, that the defendant intentionally fed these animals to create a danger to public health or safety. We covered that, and you said no, you do not. Now, do you have any evidence that she intentionally fed these animals to attract them to destroy public or private property?
Not that that was her intent, but I know she intentionally fed them.
But again, I'm asking specifically, do you have any evidence that she intentionally fed them in order to get them to congregate in a location to destroy public or private property?
No, I was speculating.
Did you witness any destruction to public or private property in the video?
Not in the video.
Okay. Did you ever witness any destruction to public or private property in person?
I just saw the aftermath of what the neighbor had told me.
But you were not there to see what caused the aftermath. You simply took the neighbor's word as to what caused the aftermath, correct?
That's correct.
So the only investigation you did was say, yes, ma'am, Miss Smith, I understand. That was the extent of your investigation?
I got it. Yeah, that'd be right.
Okay. Because you didn't make any plaster casts of the animal footprints you found, right? Or did you find any animal footprints?
No, it did not.
Okay, so you didn't make any plaster casts and you didn't find any animal footprints. So you have no way to compare the source of the footprints to the actual animal, do you?
No, I was just taking the word of what I was told.
Right. So your investigation was based entirely upon yes, ma'am, correct?
Yes, sir.
Okay. And you also do not have any personal knowledge that the defendant intentionally fed any of these cats that you see in this video or any other animal with the intent of causing 10 or more than 10 adult animals to congregate in one place at one time. Correct?
Well, I have knowledge that was personally told to me by the complainant.
Excuse me, please answer the question I asked you. I don't need hearsay testimony about what somebody else told you and that other person didn't even testify to. Mrs. Smith did not testify that she ever saw 10 or more animals there. In fact, she specifically said she never did, and she could provide no evidence to the contrary. No video, no photographs, no anything. So based upon that, have you personally witnessed more than 10 adult animals congregated on the defendant's property at the same time, and that she intentionally drew them there by feeding them?
No, I have not.
No, you have not. So you have absolutely no personal knowledge of any of the potential nuisance offenses that are codified in the ordinance, do you?
No.
No. So again, your entire investigation was based upon, yes, ma'am, and I was told to do this. I'm only following orders, kind of like the Nuremberg trial thing. Does that about sum it up?
That's how you see it.
You are correct. That is exactly how I see it. You have no personal knowledge. You were called here to testify about things to which you have no personal knowledge. And here we have finally gotten you to testify to the truth of the fact of the matter that you actually don't have any personal knowledge of any of the allegations made in the complaint. But you issued a citation anyway, correct?
Yes.
Despite the fact that none of these offenses were committed in your presence or view, correct?
Correct.
Okay. Now, I'm done with this witness. So let's move Miss Hollinger into the witness stand. Okay. Now, Mrs. Hollinger, you are the supervisor of the Animal Control Department of the City of Irving?
Yes, I am.
And Officer Delgado is an officer that reports to you?
Yes, he's one of our best. She's one of our best.
Okay. And on the day in question, did you direct Officer Delgado to go to the defendant's address and issue a citation?
Yes, I did.
And did that citation allege that the defendant was in violation of City of Irving Ordinance 6-80E?
That's correct.
And did you base the allegation of a violation of 6-80E upon a statement made by Mrs. Jody Smith?
Yes, based off the investigation, my employee did.
Again, please answer the question I asked you. Did you base your directive to Officer Delgado to issue a citation to the defendant solely on the statement made by Mrs. Smith and a copy of the video provided by Mrs. Smith?
Yes, that's right.
So the extent of your investigation was taking her statement, and did you watch the video at that time?
Yes.
And is the video the same video that we've shown in this room today?
Yes.
And you still see on the video right there that there are only 3 animals present?
Yes, it clearly shows her violating.
Again, I didn't ask an opinion about her clearly violating anything. I asked you, does it clearly show only 3 animals in the video?
Yes, it does.
Okay. Now, were you present when this video was taken?
No.
So you have no personal knowledge of anything that's going on in this video?
Not personally, no.
Okay. Now, you attempted to testify that the video clearly shows defendant in violation of the ordinance, weren't you?
That's right. That's correct, yes.
Okay. So then, in order to make that assertion, you actually have documented evidence that you brought with you, and the prosecution is, for some reason, didn't get into evidence that shows the defendant is the owner of any of the animals in this video? Do you have that evidence with you?
Yeah, the evidence shows she's intentionally feeding the animal. And
Objection, non-responsive. Do you have any evidence that you brought with you to court today that shows that the defendant is the owner of any of the animals in this video?
No, we just have the video.
And nothing in the video says, I am the owner, signed the defendant, does it?
No.
And does the fact that a person is feeding an animal constitute ownership of the animal?
It suggests it.
It suggests it. So you never been asked to go to a friend's house and feed their cat and therefore get yourself a free cat?
Not regularly, no. When they're regularly coming to my house, and they're always there, from what I've heard.
Does that automatically make you the owner, or does that just make you somebody that cares for them?
Not the owner, no.
Okay, so you have no evidence that the defendant is the owner of any of the animals in this video?
No.
No. Okay. Now, you didn't used to have a show under the name of The Amazing Kreskin, did you?
I don't know what that means.
Well, Kreskin was a mentalist. He made people believe that he could read their mind. Can you do that?
I'd like to think so.
You like to think so. Can you read my mind right now?
Yes, you're trying to convict me. Or, yes. No, I cannot. No.
Okay. Then I guess you weren't the Amazing Kreskin, because he was actually good at it. So, let's try this then. Since you can't read minds, can you?
No.
Okay. The ordinance specifically says that a person commits an offense if he or she intentionally feeds any animal or makes food available for animal consumption in a manner that results in one of the three things listed below 6-80E. Now, intent requires a mental state. Did you know that?
Yes.
So, it means that, and you're aware then that this means that the defendant had to feed these animals with the specific intent of creating one of the nuisances listed in 6-80E.
Yeah, it says she intentionally fed the animal, just as she had done.
But the ordinance doesn't say that intentionally feeding an animal by itself is an offense. It says that intentionally feeding an animal for the purpose of creating one of these three nuisances constitutes the offense. Are you not aware of that?
That could be what it says.
Could be what it says. Are you not certain that's what it says?
I don't have it in front of me.
Have you ever read the ordinance?
Not lately.
Not lately, but you directed Officer Delgado to go write a citation based upon this ordinance, didn't you?
Yeah, I trust my officer.
But your officer didn't make the decision to issue the citation, you did. And you're the one that said base it on 6-80E. According to the testimony of Officer Delgado, they took their cues from you. So you instructed them to cite this ordinance. So, are you testifying that you did not actually read this ordinance to see whether or not the charge fit?
Based off what my officer told me, I felt the charge was appropriate.
But you said you haven't read it, so how would you know that?
Look, I know how to do my job, so I felt it was appropriate.
That's the question, isn't it? If you know how to do your job, then you should have read the ordinance to verify that all the elements of the charge were met before you sent Officer Delgado out to issue the citation, correct?
Yes, and the citation...
That would be the proper way to do your job, right?
I'm not going to tell you how to do my job. We felt it was right, and that's what we did.
I'm not telling you how to do your job. You're the one who said this is how you do your job. That is your testimony. All I'm trying to get you to do is to tell us, are you going to stand on that as the way you do your job? You give directives without first doing the necessary research to ensure that what you're instructing your officer to do actually coincides with the ordinance you're telling them to use.
Well, I could have made a mistake.
You could have made a mistake. Well, let's see if you in fact did make a mistake, shall we? We've already determined you cannot read minds, therefore you could not read the mind of the defendant, correct?
Correct.
Okay, so you don't know what her intent was in feeding these animals beyond the fact that she thought they might be hungry, correct?
Correct.
And you have no personal knowledge that her intention was anything else other than to feed them because they were hungry, correct?
No personal knowledge. We just know it creates a disturbance.
Objection. That's an opinion. I didn't ask for your opinion, ma'am. Please stick to the questions that I ask you. Now, so you have no personal knowledge that the purpose of her feeding these animals, that when she fed them, that her intent was to create a danger to public health or safety, correct?
Not personally, no.
Okay. And you're just it's simply your opinion that doing so creates such a danger to public health or safety. But you're not basing that on any objective facts, are you?
I felt it was a strong.
You felt, again, your feelings are not objective, they're subjective. And in a court of law, we have to deal with objectivity and objective facts and evidence, not subjective facts and evidence. So if you would please, tell us what the objective evidence is that she created a danger to public health or safety.
We were just keeping the public safe.
Again, that's your opinion about the performance of your job, but it is non-responsive to my question. I simply ask that you answer the question I asked. You have no personal knowledge that her intent in feeding these cats was to create a danger to public health or safety, correct?
No, I do not.
And you, in fact, have no personal knowledge that any such danger to public health or safety was actually created, do you? Because you weren't there.
No.
And there's nothing in the video that identifies a specific danger to public health or safety, is there?
No.
There's only your subjective opinion that what she's doing might create such a danger to public health or safety, right? Not that it did.
That's how you see it, yeah.
Again, that's the evidence that's before the court and in this video and right in front of your eyes. Are you going to testify to something other than what the evidence shows?
Like I said, I could have misspoke, but that's how you feel.
Again, this isn't about my feelings. This is about the evidence. The evidence in the video and what is been presented by the prosecution thus far does not show that the defendant did or even intended to create a danger to public health or safety, correct?
Okay, correct.
Okay. And there's nothing that shows that the defendant intended to cause these animals to gather for the destruction of public or private property, is there?
No, not that time.
Okay. And you have no personal knowledge that that was the intent or that that even occurred, do you?
I do not personally know.
So you have no samples of the public or private property that would have had to have been destroyed, correct?
Correct.
Okay. And based upon the evidence in the video, there are not more than 10 adult animals congregated there, and you have no personal knowledge that there have ever been 10 or more adult animals congregated on the defendant's property at the same time, do you?
No.
So once again, you ordered your officer to issue a citation based upon an ordinance that you hadn't read without any personal knowledge of the actual facts or any actual evidence that the person had committed the offenses, any of the offenses, for which you were telling your officer to go and accuse them. Would that be accurate?
Could be.
Well, according to everything that you've testified to thus far, that's exactly the problem. You instructed your officer to issue a citation without any evidence of any kind that any kind of offense had even been committed.
I must have made a mistake.
That's possible. I'll grant you could have made a mistake. But you could have also just wanted your officer to cite the defendant because you've had prior experience with the defendant and don't like them, correct?
No, we don't treat the public like that.
You don't treat the public like that. You just send out your officers to issue citations without evidence. So you've done this to more people than just the defendant. Would that be accurate?
Other people have been ticketed when it's warranted for citations, yeah.
Just like the defendant was warranted in this case that you just testified that you had no evidence for when you told them to do it? Is that the kind of warranted we're discussing here?
I can't say. I don't recall. I can't tell you that.
But you just said that they're only given tickets when they're warranted after having just admitted that in this case you have no evidence that the ticket was ever warranted. So that must mean that if, by your own statement, other people have gotten tickets too, that you have issued those tickets under the same criteria as you issued this one. Maybe with or maybe without any actual evidence. Would that be accurate?
It could be.
Okay. So in other words, you don't want anyone to tell you how to do your job, but you're perfectly willing to do your job wrong. That about sum it up?
I wouldn't say that, but
And you're willing to issue and order your officers to issue citations without any actual evidence for the alleged offense that you're charging someone with. Correct?
like I said, I could have made a mistake.
Would telling someone to intentionally issue a citation for which you have no actual facts or evidence be a mistake, or would that be intentional?
If that were the case, it would be intentional. But like I said, I could have made a mistake.
But that's what you testified you did. You took a statement that made no allegation of an offense. You have a video that shows no elements of the offense. And then based upon those two things that show no crime of any kind, you still directed your officer to go to the defendant's home and issue a citation alleging a violation of an ordinance you didn't read and didn't know whether or not there was any actual evidence supporting the charge that the ordinance has in it. That is the summation of your testimony thus far. Isn't that correct?
Yes. Like I said, we make mistakes. We're so busy, we got misconstrued.
It's hard to consider something like you just testified to an actual mistake. It seems more like a pattern of behavior. If you have you testified that you have done this before to other people, therefore we must assume that this is a pattern of behavior that you do regularly.
I don't want to speak on other cases.
But you already have.
Like I said, we felt that the citation was warranted.
You felt. So again, you run your office based upon feelings, not law and facts.
As I said, we could have made a mistake.
Well, we've already covered whether or not this was a mistake, and it doesn't appear from the evidence that it was. But in any case, Judge, I'm numbing this witness. Okay? That's it, folks. That's the Columbo. Didn't raise my voice, didn't lose my temper, didn't use one curse word.
It was perfect, I thought. There's no way to get out of it, no matter what you ask.
As long as you don't let them give you a non-responsive answer and not address it, there's not. You have to make them answer the question you asked. Don't ever let them do anything but that. If they give you an answer that is not in response to what you specifically asked them, it is always objection non-responsive. Always. Now, Jane, one other thing you're going to need to file in your case, you need to file a written motion demanding a court reporter. You got that?
I can demand all I want, but they have a recorder that does it.
Jane, the only purpose of the motion is to make sure there's an official record from which they can produce a transcript. I don't give a shit if they have a court reporter or a court recording, as long as they have an official fucking record.
I was going to do that. Yeah, I was going to do that.
But you need, according to the statute, you have to ask for it.
Yeah, I know.
So ask for it.
Oh.
All right. Anybody have anything to say one way or the other about any of what I did in either case? You can do it with or without attitude and still accomplish exactly the same thing. I don't care which approach you use, as long as you do what needs to be done to show they cannot prove their case.
It's the whole case right there.
Heidi, you're breaking up again. You're too far away. You're cutting out.
It's the whole case right there. There's really nothing else to do. If she follows your lead, she wins. She may win at this level.
Well, like I said, The only thing that you have to worry about asking any questions about and getting the right answer to is what's highlighted in orange right here on this screen. That's it. You don't give a living crap about nothing else as long as you get them to admit they do not have personal knowledge of anything I've got highlighted on this screen.
Right.
This is as broad as your questions need to be. But you must make them answer the question. And therefore, you must ask your question correctly. Now, everybody see how I asked the question. I always framed it according to the language of the ordinance, to prove that they had no knowledge of anything relating to that part of the ordinance.
Right. There is no way out of it.
Okay? And the moment you get them to talk about the citation and the 6-80E, that's when you can get the statute introduced through judicial notice. Or I'm sorry, the ordinance introduced through judicial notice. Okay, so once again, what was that? That was actually, because I went Columbo slow that round, that actually took 40 minutes instead of 31. Maybe not even, it may not have even taken that because I did a little bit of discussion before I ever got to playing it. But the fact of the matter is, it was either the same or less than the previous line of questioning, where I did it in 31 minutes. But the fact is, I got everything I needed in both cases to prove they can't prove shit. And they never had a case to begin with. Jane, is there any part of this that you think you cannot do?
All of it? No.
Well, then you've got a big problem. If you
well,
cannot follow what I just did as simply as I did it, that's a big problem.
I mean, I could do it if it goes like that, but, you know.
Well, Jane, the goal is to make sure it goes like that. All you have to do to make your side of it go exactly like that is to get in the right jumping off point to get there. That's it. If they introduce the statement, that's one step. If they introduce the video, that's another step. If Delgado gives you this, talks about the citation, that's another step. We've got all three of those links right there in our chain. All three of them. Do you think they're going to talk about the citation? You better bet they are. Do you think they're liable to talk about the video? You better bet they are. Do you think they're going to talk about the complaint from Smith? You better bet they are. Now, might they use different terminology to make reference to them? Yes, they might. But you need to understand what they're talking about so that you can turn around and say, when y'all are discussing this before, are you talking about the supposed sworn statement from Mrs. Smith? Is that what y'all meant by the affidavit? Is that what you're actually talking about? And you're going to go, yeah, that's what we're talking about. Okay, great. Now you've got your stepping stone, Jane.
Yeah.
That's why you have to listen. So if they say things in a way that you don't understand, you can ask about it and get clarification for it and then go from there. All right. Anybody have anything else? We're 35 minutes past the hour here. Nope.
Nope.
All right. Well, then in that case, I'm going to consider this more or less successful tonight as far as presenting what the mock trial could be like if Jane will do what she needs to do, and how she's going to beat them if she will do what she needs to do. whether you do it as Columbo or you do it in bitch mode. I don't care. Just do it and not get yourself thrown in jail.
Okay. Thank you.
Mm-hmm. All right, guys. Hopefully, y'all like this enough that y'all sign up for the class if you're not already. For those of you that are regulars in the class, I need you to get your class fee in, please. And let's get this going. So, that said, guys, y'all have a great weekend. And
Thanks, Randall.
Catch y'all next Thursday if you show back up. Or
Thank
not.
you.
I'll be back Thursday paid. Have a great week.
Thanks, Heidi.
All right. Good night, guys.
Night.